Hello, everybody. It sure is, C-Rex. Hello, sweetie. I am so happy to have you in the chat. I've missed you. Oh, sweetie, you can. I love you. Thank you, Nana Laura. Thank you for being here. Hello, Casey Battles, honey. Oh, you make me smile with your comments. Thank you so much, sweetie. I love you. Meow to you too. Uh-oh, uh-oh, uh-oh. Those two, they kind of get into it. They fight the most out of the PAWFURM. I don't know. Tiny Kitten gets her snags in on Bandit. Hello, Manuel, right now. Hello, Terry Barnes. I've missed your big Kentucky hugs. Thank you for showing up here. I am likely to get swatted right in the face, and she don't care. Okay, you guys. So the crazy lady, yeah, today she showed it back up for the hearing. And yeah, she got worse. She got worse. I didn't think it was possible. She is insufferable. Remember the teacher that teaches law that doesn't know law? Yeah. Oh, she is something. I can't imagine why this relationship ended. It's inconceivable. Speaking of inconceivable, Nana Laura, how did your grandson like The Princess Bride? Oh, man. Oh, man. Why is that? I really liked Sexy Rexy and Crazy Old Lady and FKA, AKA Crazy Old Lady. Mystic. Oh, that is so great. Oh, I didn't forget Mystic. Hey, you cannot beat that. Hello, Lone Wolf of Soul. Oh, no, but I bet I have it. Same judge? Oh my gosh. I guess I'm gonna go have to get it while we're doing our thing. It doesn't surprise me. Because she's crazy. All right, guys. Let's get right back into this.
All right. Good afternoon, Mr. Blumberg. Ms. DeGrez, are you still with us?
Right. Yes, Your Honor. Good afternoon.
Thank you. We've gone through the docket on the other civil and landlord tenant cases. We're here on This file, which is James Dash versus Rebecca DeGrez, file 25-40752-LT. Mr. Blumberg, I know that you had a circuit court matter. Are you able to be with us for the duration now or not?
Well, Judge, if you recall, we were here a week ago, and at that time you told Mr. Grez to share with me the documents that she served on the court on an ex parte basis. I can tell the court about 10 minutes ago, while I was in the middle of another hearing in front of Judge Mertz, that Mr. Grez hand delivered these documents to my office. That's clearly not complying with the court's order.
Ms. DeGrez?
Yes, I do apologize. Well, given the holiday last week, I did attempt to deliver the documents in person on Friday to Mr. Bloomberg's office, and I found them to be closed. So I definitely apologize. I am like a single mother handling a lot of things, which is not an excuse, but I did make an attempt, and I very much apologize. So I'm ready to proceed. There's not very much in the packet if you would like to look it over.
And Judge, I don't want to restate the obvious, but she hasn't even complied with your direct order. There is no defense to this case. There was a mediation agreement that required her to be out of the premises at the end of March. She is a holdover tenant, hasn't paid rent. And if we're going to go forward, that's one thing. But if the court considers these papers, I'm going to strongly object to that.
All right, Ms. DeGrez, I gave you plenty of time to mail, to walk over, to whatever you needed to do to get the documents to Mr. Blumberg's office. You will have a chance to testify today if you want to. We will go forward with that, but I'm not going to consider any documentation that you gave to Mr. Blumberg 10 minutes ago or 15 minutes ago or whenever it was today. That's simply not enough time for him to have notice of it, to be able to react to it appropriately. I wouldn't let him do the same thing to you either. So we've got to be fair. So yes, ma'am, you have a question about that?
It's not directly related to this hearing, but there have been times where I wasn't presented with documentation that he presented to the court, and I was caught unawares. But I definitely apologize. It was not my intention. I did try to get it there on Friday.
I'm not disputing what you said, but he didn't have it. Friday was the 4th of July. Everybody's closed. I mean, that's a national holiday. Everybody's closed on the 4th of July, and I think everybody knows that. So whether you try to do it or not, I appreciate the effort, but there's no way that anybody's going to be present to take it on that day. So you will be allowed to present whatever information you have personally, but I'm not going to review the documentation that you submitted in the court file in this manila envelope that you submitted to the court. Mr. Blumberg, this is your complaint. How do you wish to proceed today by way of witnesses?
Well, Judge, I am willing to do this. I am willing to reschedule today's hearing. I have, again, only glanced at these documents. None of them really have to do with the issues, but in the sake of being fair, I'm prepared to agree to reschedule this. I don't care whether you review these documents or not. In my 30-second review of them, they deal with custody issues and things other than the landlord-tenant matter. But I'm willing to reschedule this where the court will have the opportunity to hear all the evidence.
Ms. DeGrez, is that what you want to do too? You want me to consider these documents with this adjournment?
I apologize, Your Honor. I'm just thinking for just 10 seconds.
Yep.
I just want to process
Please
that.
take your time.
I'm comfortable proceeding. I have everything in front of me. I'm organized. I've thought it over and I've studied. So I'm comfortable proceeding. I feel like things just keep getting rescheduled without resolution to.
I'm having a hard time hearing you, ma'am. I
Sorry.
don't know if you're too close or too far away from your microphone.
No, I'm naturally soft-spoken. I apologize. I'll turn this up a little bit. I have everything in front of me. I'm organized. I'm ready to proceed. I'm well studied on the matter. If you care not care, but you cannot consider the envelope, I accept that. I feel like things keep getting rescheduled to my own humiliation. So I would like to get the matter
Mr.
settled.
Blumberg, are you ready to proceed then?
Well, Judge, can I ask you this? I have this circuit court matter that is waiting for me, and that's only going to take a few minutes. Can I conclude that and then come back?
Certainly. I think that's reasonable. Do you have any idea of how long it's going to be?
It's basically a status conference.
15 minutes, 20 minutes? Is that what you're looking at?
Yeah, I think so.
All right. Ms. DeGrez, are you still available in 15 or 20 minutes?
Yes, sir.
All right. I'm simply going to call a recess in the matter for 15 minutes or 20 minutes. I will leave the connection open. Both of you can turn off your cameras or however you want to do that. The court's going to step away from the bench for about 15 minutes, and then I'll come back. Mr. Blumberg, as soon as you're done, if you see the court's not on the bench, if you'd simply give us a call, I'll return to the bench immediately afterwards. Ms. DeGrez, if you would simply hang around and be available. But I don't think it's necessary for either one of you to stay on the court's camera, so we're staring at each other. So we'll do that, and then we'll be back in 15 minutes or so, and then we'll proceed. All right. Thank you. Go ahead, Mr. Blumberg. Yep. All right. Court will recall the matter of James Dash versus Rebecca DeGrez. That's file 25-40752-LT. See that Mr. Blumberg is back. Do we have Ms. DeGrez with us?
Hello.
Ms. DeGrez is with us as well. Mr. Blumberg, are you able to stay with us for a while now?
I am, Judge. Thank you. I appreciate it.
All right. The case is with you to start, and then we'll hear from Ms. DeGrez afterwards. How do you wish to proceed?
Mr. Dash, I think appearing via Zoom as well. I think he's muted.
Mr. Dash, are you with us? If so, I need to see your video on and your audio available.
Yeah, I'm here.
Need to see your video, sir.
Can you see me?
I can. Thank you very much. All right, Mr. Blumberg, go ahead.
Judge, let me, if I may, just take a moment to give you an overview of where we're at in this matter. Mr. Griffith is the mother of my client's child. In the midst of a custody dispute and parenting time debate, the parties came to an agreement whereby Ms. DeGrez would be able to remain in the residence owned by my client, and that is at Gaylord, Michigan. She was allowed to stay there for a period of time with the understanding that at the end of March of this year, she was to vacate the premises. That was memorialized in a mediation agreement between the parties and signed by the parties and their respective counsel. In consideration of that, certain monies were to be deducted from Mr. Dash's child support obligation. Well, March came and went, and Ms. DeGrez has remained in that property since then. She's been served properly with a notice to quit and a complaint to recover possession of property. Her defense is, as I read it, or at least as I hear it, is that she's a single mother and she has no place to go. And there were other, I guess, conditions that she believed would somehow allow her to stay in the property. The reality is that she has no legal right to remain there. She's been a holdover tenant since March 31st, and we are simply seeking the court to enter an order to recover the property for my client. Mr. Dash is here today, if necessary, to testify to those things that I've just represented to the court.
All right. Ms. DeGrez, do you disagree with anything that Mr. Blumberg has said?
I would dispute
You
nearly
have to
everything he had
talk a
said.
little bit
Oh, I'm
louder
sorry.
so I can hear you, ma'am.
I apologize. I would in fact dispute that almost everything he said and the eviction itself.
Is there an agreement between the two of you for you to be out at a certain date?
Yes, sir. If I may provide background as well, just briefly. I am the primary caregiver, sole caregiver of our shared minor son, Colton, and I have maintained the stable residence since November 2019. We did enter a mediation agreement that was dated August 1st, 2024. It did include.
Ma'am, every time you look to the side, I don't have the ability to hear you then. So you either
Okay.
need to move the paperwork closer to the microphone or change something somehow so I can hear you.
Yes, sir. I do apologize. The plaintiff and I did enter into a mediation agreement, which was dated August 1st, 2024. There were specific terms in that agreement that do apply directly to our situation now. First was conditions related to payment of the arrears by the plaintiff, which was conditional then on my move out. There were additional financial and logistic responsibilities, as well as within the mediation agreement, there's a mutually agreed upon review to revisit mediation before summer 2025. I did make several attempts with community mediation services. They did reach out to James and Mr. Bloomberg, and my attempts for further mediation were denied. There was no final eviction or move out date unless said conditions were fulfilled in good faith. And there's more. There was no official lease. It was just the date in the mediation agreement. There was no official agreed upon terms outside of that date with the various conditional matters I had already stated. Additionally, Mr. Dash did unlawfully lock me out on March 18th, 2024, violation of MCL law 600.2918. I do have video proof from the Michigan State Police, 2 10-minute videos with Trooper Hop of Mr. Dash changing the locks on Colton and I, and not allowing us back in.
What was the date on that? What was the date of that?
March 18th, 2024. So this would have been just as like within process of trying to get the PPO.
Of 24 or 25?
24.
Well, that would have been before the lease agreement or the mediation agreement, I mean?
Yes, and there was no, I asked for a lease. I was never given a lease.
So the illegal lockout, you say that there wasn't a lease agreement. How did he illegally lock you out if there was no lease agreement?
So this was documented in the PPO. Not resistance. When he had disputed the PPO, there was like a 3-hour court we had with Honorary Judge Mertz, and so this has all been documented. I would think well documented.
I'm not disputing the documentation, but the question I have is how would it violate the
Yes, sir.
landlord-tenant law if there was no lease agreement and this happened prior to the mediation agreement?
Due to domestic situations at the time, Cole and I were living there by ourselves, and Mr. Dash had become very threatening. So I left the house for the night to go to my mother's. And then when I returned the next day to try to get Colton's things, he had locked us out. And so I had requested police assistance out of Peter, and they did record that interaction. That was Trooper Hop. So there's never been a lease in place is what I'm saying. And I've definitely tried, but I believe it's always illegal to change the locks on someone's place of residence, which it was clearly mine established since November 2019.
All right, but then you stayed with him for the end of March, April, May, June, July, and then August before the mediation agreement, right?
No, sir. Mr. Dash was not present at the home after a domestic incident in August. And
So up to that point, were you residing together?
up until August 2023, yes, until that reported domestic incident, we were. Yep.
Until August of 2023, they were living together. So he moved out of the home in 2023. She continued to live there rent-free until now. This woman is absolutely the epitome of everything we don't want to be. I couldn't imagine having the gall. And then to call herself a single mother. I'm sorry. No. No. You're living rent-free, probably bill-free, off of this man. You are not a single mother. He is providing for his child. For sure.
So you're alleging that he changed the locks in March of 24?
That is correct, sir.
Then you reached a mediation agreement in August of 24.
Mm-hmm.
All right. I just wanted to make sure that I understood your timeline. Thank you.
Okay, I have more in case you need more.
Well, let's take your statements one at a time. Mr. Blumberg has said that there was a mediation agreement, and it appears that you agree with that. And I'm looking at it. It's dated Thursday, August 1st of 2024. And it does say down near the last paragraph, the opening sentence says, both parties agree that Rebecca will stay in the home owned by James until March 31st, 2025. Am I quoting that correctly?
That is correct, sir. Based on the conditions.
You are alleging that there are some caveats to that, some conditions on that.
Absolutely, and other illegal bad faith things.
I'm sorry, I didn't hear what you said.
I apologize for interrupting.
No, you're fine.
I said as well as further actions by the plaintiff that I would consider illegal and against, like, the eviction
right, so
in general. The date.
Let me take these things one at a time then, so I can understand them in order.
Okay.
What is your first reason for believing that there's an additional condition in play? Start with your first one, and we'll take them in order.
Okay. And just one little bit of background. The mediation did go for hours.
I'm again having a hard time hearing you, ma'am.
I'm so sorry. I keep trying to speak up. It could be my computer as well. I do struggle with Zoom. So during the mediation agreement, it did go on for hours. I was under like severe emotional and mental duress, and I did agree because I felt I had no other choice.
Judge, I object. First of all, as you well know, what goes on at mediation is confidential. The mediation agreement reflects the agreement of the parties and their attorney. She was represented by counsel at the mediation. So any discussions about what went on in mediation, I believe, is improper.
All right, ma'am, counsel is correct. An agreement is an agreement. It really doesn't matter how it got there or when it got there or under what circumstances it got there. This is an agreement. It appears to me that it was, has this been entered in a court order that solidified this? I assume in the custody proceedings?
Yes, Judge, it has.
Ms. DeGrez, do you agree with that this has been solemnized by a court order so that it's a binding agreement on the parties?
Yes, sir. I have the dates here as well. I was with Honorary Judge Mertz. I would just like to add, though, if
it's not honorary judge, it's honorable judge.
Just given the context,
all right, so
matters and like that the threat, like I felt very threatened. I still do.
Ma'am, whether you felt threatened or not isn't going to change anything. If this is a court's order out of this mediation agreement, it is what it is. Whether you agree to it willingly or unwillingly or under duress or whatever, I can't change that now. All I can do is enforce what it says. So both parties have agreed that there was a mediation agreement. Both parties have agreed today that this was been put in place under a court's order in the custody and parenting time case. So I need to know whether or not there are these conditions that you allege to this agreement. So the agreement says in one sentence that you're supposed to be out by March 31st. What do you believe allows you to stay after that? What are the conditions that you outline? So lay them out for me and we can take them one by one. So what's your first condition?
Yes, sir. I would be the parent condition. There was no lease given to myself.
Ma'am, I'm sorry, but every time you turn your head, I cannot hear you. So if you want to have me hear you, you have to face the camera and speak directly into the microphone.
Okay, I'm so sorry. I just get a little nervous. So I think foremost, there was no official lease telling me any further terms. In a lease situation, there's usually like a month to month that happens, and that would just be like the very tip of the iceberg. Is there not being a lease, me asking for a lease, not being provided with one, and repeatedly like trying to go through community mediation. So I'm not even sitting in front of yourself right now. So that would be the first, no lease. There's
Okay,
several things that.
So the first one is no lease. Mr. Blumberg, your response to that?
Judge, there didn't need to be a lease. It was a verbal agreement reduced to writing that allowed her to stay in the home until March 31st of 2025. Any other terms in terms of who was paying the utilities, none of that was an issue or a factor in her ability to stay there. And again, there were no conditions. If the court reads this mediation agreement, there's no language in there that says the right to stay in the property is conditioned upon Mr. Dash complying with all other terms. Because if that's the road where she's going down, the fact is she has been the one that's denied my client parenting time, which was granted by the mediation agreement.
Well,
so there didn't need to be.
I'm not here to, sorry to interrupt, but I'm not here to do parenting time. This is a landlord-tenant matter. That's a different court. That's a different proceeding. So the issue is whether or not the fact that there was no written lease allows her, or is a condition, would allow as a condition for her to stay longer. I know of no legal precedent that would say that that is true, ma'am. The fact that there was no written lease may have enforcement consequences as far as him requiring you to pay rent, but I don't know of anything that says that you get to stay longer without his permission. And clearly he has revoked that permission at this point. So I don't know of any legal requirement that says that you are allowed to stay other than by the party's own agreement after you've reached an agreement that says you are to be out on a certain date. So I'm going to deny that as a basis for allowing you to continue to stay. What is your second reason that you believe would allow you to stay longer than March the 5th, March 31st?
Okay, very good. So I do disagree with Mr. Blumberg. Verbally within that mediation, it was known or agreed that the payment of the arrears was how I was going to move out of the house as well. Like, it's pretty conditional on it.
So the second basis is that you believe that he had to repay child support arrears in order for you to be required to move out of the home. Is that
yes,
correct?
sir. And yes, sir. I do have documentation of all the payments, which I've submitted. I think Mr. Blumberg does as well, but I've never seen James' documentation of the payments, so I'm not aware the truthfulness of what was submitted. Yes, so as I took it, the move out date was based on his fulfillment of said obligations. He failed to pay, he failed to mediate, and he acted unilaterally against several court Matters, his own lawyer, myself,
Okay.
good faith. Yes.
All right, so hang on, let's not get too far ahead of ourselves. So the second reason that you would think you should be able to allow to stay is that he failed to pay the arrears that are referred to in the same paragraph, where it says, Rebecca agrees that there will be a monthly rent of $1,500 beginning the first of the month following the child support arrears being paid in full. Rebecca agrees that the rent money can be credited toward the child support beginning the first of the month of the child support arrears being paid in full. And then James and Rebecca will provide receipts of payments as a credit since March of 2024 to both attorneys on the child support in arrears. So you believe that those three sentences together give you a condition that says that you can stay until he pays off the arrears. Is that what you're arguing?
Yes, sir.
I can't. I
I'm
can't
so
hear you
sorry.
again.
I would have liked the mediation agreement, that paperwork to have fleshed that out more clearly for me, just as I had asked several times for a lease, so I understood all of the terms,
No,
and I was
I
never
can't
provided.
change it now. All I can do is try to give effect to
Oh,
what it
yes.
says. So
Okay.
that's the three sentences that you want me to consider on your argument. Is that correct? That's what you think says that you can stay there longer if he doesn't pay the child support arrears.
That's what it says, so, yes.
All right, Mr. Blumberg, your response to that.
Well, two things. I don't believe it says that. And more importantly, he has paid all the arrears. There is no child support arrearage at the current time.
And how do I know that?
Well, Judge, that's a custody and parenting time issue that you're not going to be addressing today. So I can assure the court that the front of the court would be filing motions against Mr. Dash if he was in arrears.
They have,
All right.
there's several motions. There's 61 items.
All right. Here's the language says that there will be monthly rent of $1,500 beginning the first of the month following the child support arrears being paid in full. From this document alone, I can't tell when payment of rent was supposed to start. It would be some point in the future from the date of this agreement, whenever the child support was paid in full.
Yes, when the arrears were paid
The
in
next-
full was when that would start. There is no
Okay, so
payment
that's-
on the house as well. The house is paid off. That's an important
right.
detail. Yeah,
So-
there's no
Nothing
payment
to
on the
do
house.
with it.
All right,
The
hang on.
mortgage is paid.
All right, stop. Let me process it. The next sentence says that Rebecca agrees that the rent money, when paid in the future, can be credited toward the child support beginning the first of the month of the child support arrears being paid in full. So there's another in the future thing gonna happen. So rents in the future, rent being being placed towards or credited towards child support is in the future, again, after child support is paid or the arrears is paid in full. And then the only other sentence that's there says that Rebecca and James will provide receipts of payments as a credit for what has been paid since March of 2024. So something in the past. So I got two sentences that deal with something in the future. And I got a sentence that says something in the past, and we're going to try to work all of this out about the arrears. It doesn't say anything about condition on when you are to move out of the house. It is rent for while you are staying there. Which would start in the future if the arrears are paid off. I assume if the arrears are not paid off, you would never owe rent. And all it is, all that language is conditioned on rent being, or excuse me, arrears being paid first. But if it is, then you owe rent. If it's not, you don't owe rent. It's got nothing to do with how long you stay in the house.
Okay.
Okay, so I can't find any reason for payment of arrears to be allowing you to stay within the home. Okay, so your next allegation of a condition is that you said he failed to mediate as to parenting time. Is that correct?
Well, that in the matter of the house.
I'm sorry,
that was-
that in the matter of what?
The house, that and the matter of the house. That was to be discussed in mediation.
What about the
It's
house
not,
is to be discussed in future mediation? What about the house was supposed to be discussed
sorry.
in future
Our-
mediation?
Our shared minor child and I staying longer than the date in the mediation agreement was to be
Where does
discussed in the
where
mediation.
does it say where does it say that that's going to be further mediated?
It does not, sir. I would have liked it to be included, but I don't have control.
Well, you did at the time of mediation. You could have put that in there, but you didn't. So that's what I'm asking you. But did I miss something? I don't see it within this mediation agreement that you're going to come back and do future mediation on how long you get to stay in the house. Can you point that out to me, or is it not there?
It is not there, sir. You're correct. It would have been nice to have an addendum on that sentence that said, and as well as the house.
All right. Well, all I can do is enforce the agreement as it's written. So
Yes, sir.
I'll have to deny your request based on the failure to mediate on the house because it's not within the document. And it doesn't appear to me to be a reasonable reading of what the document says to imply that or to infer that at this point either. Because future mediation is stated previously, I believe, 4 paragraphs above that. James will have 6 weeks of parenting time commencing in the summer of 2025. If the parties cannot agree on the schedule, they agree to return to mediation. So there is a paragraph in there that talks about returning on a specific item. So you could have put that in there about the length of time you were going to stay in the home, and that wasn't done there. Is there any other condition that you have that you believe allows you to stay within the home?
Yes, sir, I do.
Go ahead.
I may proceed. So the unlawful lockout of 3/18/24, of which I have trooper video from, is that not relevant?
Okay, so the lockout
Legal
of
action?
March 18th of 24,
Mhm.
which is approximately 4.5 months before this mediation agreement, why would that allow you to stay longer than so you have the lockout in March, you have the mediation agreement in August of 24. Why would that extend the period for you to stay that you reached in mediation in August? Why would a March event change an August agreement?
Okay. Feel free to interrupt me. This might be.
I'm sorry, ma'am, I can't hear you.
I said, feel free to interrupt me. This might take me a minute.
I still can't hear you for whatever reason.
I don't know if it's the microphone or here, let me pull that out.
If you're close enough, I get you, but as soon as you back
Okay.
up a little, I can't hear you.
I just don't want you to see my whole face. So, okay, here we go.
Your whole face is just fine. I don't have a problem looking at your face. So you're
Okay.
good. I just need to hear you because it's important.
Okay. Yes, very good, sir. So feel free to interrupt me. I would like to respond to that.
Go ahead. Yep.
This is just one item that reflects a pattern of control that the plaintiff has exercised over myself for over a decade. There was a criminal case that was pending that was led to a plea deal just this past week and additional humiliation on my part.
Judge, I'm going to object to this. It has nothing to do with the landlord tenancy
I'll get
matter.
there.
Excuse me.
I'm getting there.
Let me just finish for a
Ms.
second.
DeGrez, hang on, both parties, hang on. Let me explain it to her. Ms. DeGrez, Mr. Blumberg has the right as an attorney to object to an argument or a statement that the other side makes. So he's made an objection. I'm then going to come to you and you're going to tell me where it is that you're going with this argument, and then I'll rule on whether or not it's going to be allowed. So he says that your argument that decades worth of alleged bad behavior on Mr. Dash's part isn't relevant to this agreement. So I want you to tell me why you think it is.
Myself, yes, me.
I'm
Mr.
asking you that. Yes, go ahead.
Okay.
Tell me why I should consider it.
Okay, I believe this attempted eviction is a clear act of retaliation and harassment intended to punish me for any testimony that I would have put in for the case that was just decided this past week, continually undermine my stability and safety, and coerce me into silence. The threats placed on both myself and our shared minor child put us at severe risk of homelessness. our child will lose shelter, safety, schooling, community, access to care. We're very well established in the community. I work at the high school. So this constitutes child endangerment on Mr. Dash's part for forcing an eviction for his minor child that very much doesn't want to move. Under Michigan law, MCL 722.622. So I consider this to be like a retaliatory eviction and leading to child endangerment.
Okay.
I have more as well.
But the idea behind all, you want to explain in a little more detail as to what he's done to you that causes you to believe it was a retaliatory eviction. Is that correct?
I can
All right.
I can do that.
I just want to make sure I understand your argument first. So Mr. Blumberg has objected. You've said you believe it to be a retaliatory eviction. I'm going to give you the opportunity to tell me quickly, but I am going to give you the opportunity to tell me why you believe that this is a retaliatory eviction. Go ahead.
There's been a long pattern of threats and documented 911 calls from situations with Mr. Dash. I've continually felt threatened by both himself and his counsel. There was a letter sent by Mr. Blumberg to the state police, the county police, that I was not even supposed to be allowed in my home until the PPO was upheld by honorary Judge Mertz. So I have felt threatened all along, and there is documentation of it, including the lengthy PPO hearing that we had that supports that. Let's see, I have more. I do feel like it's a violation of my rights as a tenant, as a mother, and a survivor, and I'm just asking for continuity of housing for Colton and I, or even for the parties to agree to revisit this matter in mediation. I would really just like to talk it out, not in this setting. Or an extension. Our son really just doesn't want to move.
Anything else that you want me to be aware of regarding this claim of retaliatory eviction?
Just give me 1 second so I can look over my notes.
Again, ma'am, you're too far away from the microphone. I can't hear you.
Just give me 1 second so I can look over my notes.
Yep, go ahead.
Let's see. Fulfillment of obligations, arrears, engagement, mediation, fail to pay, child endangerment. Oh, I feel that the threats are retaliatory based on my reporting of these incidents. Like I said, there's multiple calls, documentation with both state troopers and county police. And I feel like it is also retaliation for my cooperation and respect for the legal system and for law enforcement. To my knowledge, like it would constitute grounds for court protection, which I currently have in a no contact order, not for eviction.
Right. Is there anything else that you want to tell me about regarding the retaliatory eviction?
No.
All right, Mr. Blumberg, your response to that.
Judge, this is hardly a retaliatory eviction. This is a date in which she agreed to vacate the premises. She has been there improperly as a holdover tenant since March.
Careful, Mr. Blumberg. You are threatening and intimidating her right now. You are such an intimidating beast, you.
April, May, June. Here we are in July, and she still refuses to vacate the property and asserts some ridiculous claim of retaliatory eviction and child endangerment. The fact is she was a guest in my client's home up until the time where they separated. And when we entered into this agreement, the parties agreed she would stay until March 31st. That's why my client is seeking to regain possession. She has no legal right to be there at this point. We would ask the court to disregard any claim of retaliatory eviction.
All right. Ma'am, I can certainly understand emotionally why you would believe that you are being threatened or that you have in the past been threatened. I can certainly understand why it would be emotionally difficult for you to leave the home and why your son would not necessarily want to leave the home. But I find no legal basis for believing that this is a retaliatory eviction. The date noted in the mediation agreement and subsequently affirmed by the court's order was that you were to stay in the home owned by James until March 31st of 2025, which means that after that time, he has a proper legal basis for asking that you be, in essence, be evicted. He has taken advantage of that. There is no indication on this record that he has, by filing this action, that he has violated some other law or some other court order. I've not heard or seen any indication that the custody or parenting time order has been violated or that the personal protection order has been violated by this request. The request is a normal, legal landlord-tenant law request. It's not, he didn't self-help. My original thought when you first brought up the lockout was that that was in March of 2025 and that this was somehow a self-help cause of action and that you were objecting to that. So I see no action by either Mr. Blumberg or by Mr. Dash that is retaliatory. They are simply using the court system to enforce a legal right that you agreed to when you reached the mediation agreement and that the court affirmed when it entered the court's order in the custody and parenting time thereafter. For that agreement to have any effect, the court has to be able to enforce it. And the court, the mediation agreement and the court order very clearly says that you were to stay in the home until a specified date. You have now exceeded that by a number of months. It was supposed to be March, the end of March this year, so April, May, June, and now we're through the first week of July. You have exceeded that time period. So I'm going to deny that as a reason for allowing you to stay further within the home. Do you have any additional conditions that you believe would allow you to stay within the home outside this mediation agreement?
Did you refuse the child endangerment situation with him then forcing his minor child to be homeless?
The statute that you cite, MCL 722.622, is the child protection statute, and it basically is the definitional section. It does not contain a specified definition of child endangerment. There are certainly definitions of neglect and abuse, child abuse, serious abuse or neglect, all of those kinds of things. But the only child endangerment statute that I'm aware of in the state of Michigan is drunk driving with a child less than 16 years of age in your car. That's called child endangerment under the Michigan statutory scheme. I understand what you're saying, that by kicking your son out of the house at or without you having another place to go might be some sort of abuse or neglect in your mind, but I don't find that as a matter of fact today, because I don't know under what circumstances you would be able to move the child. And if you are the parent, as you've alleged, if you are the parent with custody at the moment, where the child is going to stay would fall on you first, even if you were. So if this was a third party that was saying, hey, you haven't paid your rent, I'm going to kick you out, it's not abuse for that landlord, whoever that landlord would be, to remove you from the home. Even if you were to be homeless at that point, it would be your job to find the child immediate shelter. And if so, I can't make a finding of fact that says that his use of the court system to enforce a right that he has is child endangerment, because it's not a statutory phrase or a violation. I also find that it's not neglect or abuse under these exact circumstances as I have them today, because you are able to provide, even if he was to kick you both out, he knows that you are able to provide for the child's immediate safety and find the child an appropriate place to stay immediately thereafter. So I don't find that that is a proper basis for action to extend the time period for today. Is there any other condition that you would propose?
May I just point out a specific law?
Go right ahead.
750.161. And I hear you. I understand what you're saying. In section 161 of that, in reference to Mr. Dash, a person who being of sufficient ability fails, neglects, or refuses to provide necessary and proper shelter, food, care, and clothing for his or her spouse or his or her children under 17 years of age is guilty of a felony, punishable by imprisonment, etc. He meets all of these things. Like, he has not provided necessary shelter, food, care, clothing. Yes, just to give you, because you had said, and you are correct, that's just like a very simple, like stating what the law is, the first one I named, but this one kind of fleshes that out a little bit more. But I do accept as well what you are saying. I do not feel like we can look at this from an objective perspective, as this just my landlord. This was our family home. We worked for together, paid it off together. There's no mortgage payment on the house. And I'm trying to advocate for myself and my son.
How can you say with a straight face that he has not provided for his child when you've been living in that house rent-free for 1.5 years without him there? It sounds like up to this point, he really has provided for his child.
Mm-hmm.
I don't have a problem with you advocating.
I do not.
I don't have a problem, ma'am. Ma'am, hang on.
Oh.
I don't have a problem with you advocating for yourself and your son, and I think you're doing an admirable job. So that's not an issue. The issue is, that's all that's in front of me today is landlord tenant.
Mm-hmm.
Does a landlord have the right to remove a tenant when there's an agreement between the landlord and tenant to move at a certain date? And the answer to that question is yes, he does. And simply by removing the tenant, if the tenant has a young child, does not cause the child to be neglected or abused, because the tenant can provide for the child's immediate welfare by getting a motel or getting a hotel or going to a homeless shelter or renting another place. So it is not abusive or neglectful, even if the landlord is the father of the child and knows that the child is going to be removed from the home that the child believes is its long-term home. That may have some emotional impact on the child, but by and of itself, I do not believe that it is neglectful to the point where it would overcome the landlord-tenant laws. If you disagree with me, you may certainly report it to Child Protective Services. They may do an investigation, and if they believe that I am incorrect, they can bring that by way of a child protective proceeding in court, and I would review it again at that point. But as of today, the landlord simply enforcing an agreement reached with the tenant for a date to be removed from the home does not amount to abuse and neglect. Do you have any other conditions that you believe would allow you to stay within the home longer than the date that you agreed to?
Let me just look. They are rather backed up at CPS too. They're very busy over there.
I deal with them every day, so I know exactly how busy they are.
I know.
Correct. So
They really are. They're doing the good work.
Judge,
Right.
can I respond while she's looking whatever it is she wants?
Yes, sir.
If anyone is neglectful in this situation, it is Ms. DeGrez. She is the individual who cannot provide for her child. My client, at a moment's notice, can provide this child with housing, food, and clothing. So if she wants to go down that road, she is the neglectful parent, not my
Love to go
client.
down that road. Sir, I would love to go down that road. Like what, 230 miles away? 230 miles away, sir.
Stop. Ma'am,
Sir, the false
as I've
narrative
said,
and the
ma'am,
humiliation is not acceptable.
ma'am,
I'm sorry.
as I've said before, I'm not going to consider what Mr. Blumberg said because I'm not here on abuse and neglect. I'm not here on custody and parenting time. I'm not here on any of that. This is landlord tenant. I don't take what Mr. Blumberg said as a statement of fact. He's an advocate for his client, and that's all that was there for. So please review your notes, do whatever you need to do, take a minute to think about what you need to do. And then all I need to know is, do you have any other reason for believing that you can stay longer than March the 31st in the home?
I'm reviewing.
Go right ahead.
Okay. I guess they have a closing or like, yes, I can talk. Very good.
Go right ahead.
I would request the court not to think of this situation as a contractual dispute. It is a matter of child safety, survivor protection, and a parent's right to remain housed while completing a master's degree and caring for our shared son. The plaintiff's actions are consistent.
Right there, we just learned the whole of it. She's getting her master's degree. Has nothing to do with her child at all. She just wants to not be inconvenienced while she's in school.
The long standard pattern of abuse and retaliation, and this should be evaluated as such in any legal setting, especially as it pertains exactly to this. I don't believe it could be looked at objectively as a landlord-tenant typical situation that you described. I do understand what you have said. I agree with this very much. I would like the court to consider the non-performance and retaliatory motives of the respondent with this, and please just uphold my continued right to reside at my home at minimum until a mediation session can be held and we can agree on further terms. It's in the best interest of our child. But again, like you said, I realize this is not a custody dispute. From my perspective, I felt like it was in bad faith the arrears weren't paid, and that was verbally discussed, agreed upon. And it is to my detriment that it's not an addendum within the mediation agreement. I did request an addendum to the mediation agreement in January as well, and I have been denied continually. That is all, sir.
All right. Mr. Blumberg, do you want any response?
Just briefly, Judge, and I'll try to stay on point. Contrary to what Mr. Grez says, this is a contractual situation. There was an agreement freely and voluntarily entered into by the parties. It specifically gave Mr. Grez the ability to reside in that place until March 31st of 2025. In spite of our numerous requests to peaceably ask her to leave, she refused to do so. And we had no choice but to bring this action, seeking the court ordering her removal from the property and retaining possession to my client, the rightful owner. This isn't about custody. It's not about child endangerment. It's about my client's legal right to retain his property. Thank you.
All right. Ms. DeGrez, I can certainly understand, as I said before, the emotional impact that the request to leave the family home and the whole home that you shared with your child for a long period of time, why that would have some emotional connection to you and why that would be difficult, probably economically, emotionally, socially. However, this is nothing more than a common, ordinary landlord-tenant matter. This is a holdover on a verbal lease, if you will. The parties mediated that as a part of the custody and parenting time portion of your relationship. That was reduced to an agreement. The parties with counsel agreed to have you move from the home on March the 31st. Mr. Dash and Mr. Blumberg are simply asking that the court now enforce that through the appropriate contractual landlord-tenant process. You have been given every opportunity to produce to me a landlord-tenant reason why I should not do that, why I should allow you to stay within the home for a longer period of time, and you've not given me any legal basis for doing so, other than it would be hard for you, it would be hard for the child, and you would like some grace. Unfortunately, I can't make one side agree to something that they do not wish to. The parties reached this agreement. I can only enforce what the parties agreed to, and that's what I'm going to do in this particular case. Mr. Blumberg, do you have a proposed judgment for me to sign today or not?
I do not, Judge. I will provide that to the court tomorrow, certainly at the earliest, or maybe later today. Although it's
all right.
Mhm.
Why don't we do that under a 7-day notice? She would be required to be out within 10 days of today's date. That's the most time that I believe that I would normally be allowed to give her. So ma'am, you have 10 days from today's date. Mr. Blumberg is going to send me the original and send you a copy of a proposed judgment. If you disagree with, not with what my ruling is, but what his order says, whether it if it differs from what I have said, then you have the right to object to it, and you must do so in writing. If you don't object to it, I will sign it in 7 days, and it will become the order of the court. Do you have any questions, ma'am?
Just, I suppose one, a lease would have been very helpful. The fact that there's not one, I think is a glaring oversight to all of it. Like you said, it's just one sentence. And I begged for a lease.
I don't disagree with you that a lease would have been very helpful, but it wasn't there, and I can't go back and change history. All I can do is base things on how the law typically works. There are lease agreements where nobody writes it down. It's not supposed to be that way, but they do that. People let people stay in their house all the time. And if they hold over after they've been told to leave, we do the landlord-tenant stuff. So it's not out of the question to have a non-written lease. And so that's what you have in this particular case, a non-written month-to-month lease. You're a holdover after you agreed to go. And so I'm treating you exactly the same way I would treat anybody else that comes before me with the same kind of claim. You have these rights. We went through the reasons why you might stay, and I found for the other side, and I believe that they are being upheld in the proper way to proceed. So all I can say is Mr. Blumberg is going to submit an order that comports with what I've said today. You have 7 days to object to that once you receive it. If you don't object, I'll sign it. If you do object, we'll have another hearing on it, but you've got 10 days period to be out. Okay. All right. That's all for today then. Thank you very much.
Judge, can I just ask one last thing? I want to make sure we all understand.
Yep.
Well, she has the right to object to the form of the order, but not the court's ruling. I'm not sure she understood that.
That's correct. And she has the right to appeal if she wishes, but she'd have to do that appropriately. And I don't know whether the next court would accept it or would adjourn it or hold it in abeyance. So all I can say is that's the ruling that I've made. Mr. Blumberg is going to submit the order, and we'll take care of things in the due course as they proceed on down the road. Thank you all very much.
Thank you.
With that, the court will be in recess.
Oh, that was glorious. Okay, guys. So, Lone Wolf Lassalle, he was in here at the beginning of the stream. He said that there was a hearing on the 3rd because she called the cops on the husband. And he sent the video to me. I have not seen it. So, let's watch it together.
Two things for Sweeney.
So the felony was the one that you signed right before court. She's represented in the felony case, and they used to just sign the adjournment. She's unrepresented on the misdemeanor case.
Ah. Okay, thank you. All right, the next matter is State of Michigan versus Asante Swain. That's file 25-43804-ST. It's a misdemeanor matter. We have Ms. Swain with us today.
Oh, hold up, guys. I think he sent me the entire docket from that day, but he told me that it starts. Oh, no. Oh, come on, Lone Wolf. Hold up. I mean, maybe Asante Swain is good too.
All right, the next matter is State of Michigan versus Asante Swain. That's file 25-43804-ST. It's a misdemeanor matter. We have Ms. Swain with us today.
Yes, sir. The camera's not working somewhere. Can you hear me?
I can hear you, but I cannot see you.
Okay, I'm on here now.
There you go. I see you now. All right, Ms. Swain, this is, I just called the misdemeanor case that you have pending. This is a date and time set for a status conference. It's my understanding that you do not have an attorney on this case. You have also a felony case, and I just recently signed an order adjourning that matter. So I'm not going to call that case. Do you want this case, the misdemeanor case, to continue, or do you want it to adjourn it until we have a resolution of the felony case?
I just push it back?
I'm sorry, I didn't understand what you said.
Did you say, did I want to push it back?
Correct.
Yes, sir.
All right. Are you in contact with your attorney in the felony case?
Yes, sir.
All right. I know that attorney is not representing you on this misdemeanor case, but often the attorney is able to discuss what's called a global resolution. That is a resolution of all the cases all at the same time with the prosecutor. So I would ask you to get in contact with your attorney on the felony case and see what type of resolution they might be able to make an agreement with the prosecutor to see if they can resolve both of these cases. If they can't, that's fine, but I simply want you to have that opportunity. And so what I'm going to do today then is simply adjourn this matter out. Still good on the 18th?
So this one's scheduled for her felony case is scheduled for the 17th. So we'll put it on the 17th as well.
All right, so we're going to move it. We're going to move it. So this case is at the same time frame as the felony case, which would be on July the 17th. Is that in the afternoon docket?
Yeah, 1:30.
It'll be at the 1:30 time frame on the afternoon docket. So make sure you get in contact with your attorney on the felony case, discuss the misdemeanor case with him, and then I'll see you here on the 17th, which is a week from today, 2 weeks from today, at 1:30, and that will be via Zoom, just like today. All right?
Yes, sir.
All right, that's all for today then. Thank you very much for your appearing, and I'll see you on the 17th.
Yes, sir. Thank you.
Next matter is the State of Michigan versus James Dash. That's file 25-43580-FY, set for a status review. Mr. Blumberg, is that your case?
Yes, it is, Judge. Thank you. Elliot Blumberg on behalf of Mr. Dash.
Is your client here today? Is he with you?
He's appearing via Zoom.
I do see him now. I just lost him in the shuffle.
Sure.
All right, Mr. Dash is here. Ms. Bruker is here as well. This is a time set for a status review. Do we have a resolution of this matter?
Yes, Judge, I believe we do. After negotiations with the prosecutor's office, my understanding is that counts 1 and 3 of the complaint will be dismissed. Mr. Dash will be pleading no contest to attempted resisting and obstructing. And the reason for the no contest plea is that there is ongoing litigation with the mother of his child arising out of this incident.
So if I can, Elliot, the way the court will structure it is it'll be an added count for attempted resisting the obstructing, and we would dismiss counts 1 through 3.
You know, I wasn't sure how you did it. I thought it was a lesser included in count 2. Whatever, however we need to do it would be fine.
It's just cleaner if we add a count 4 for the paperwork purposes, but I appreciate the information. All right, Mr. Dash, do you understand what the lawyers have said?
Yes, Your Honor.
And is that what you want to do?
Yes, Your Honor.
All right, listen carefully because there are some rights that you would be giving up if you want to do that. And I want to make sure that you can make an informed decision about doing so. Right now, you're charged with 3 counts, which include count 1, attempted home invasion in the 3rd degree, count 2, police officer resisting and obstructing, and count 3, malicious destruction of a building. There would be an added count 4 that would say that you did attempt to resist and obstruct a police officer, being Troopers Kennedy and Trooper Weiner. And then the other 3 counts would be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
And that you would do this by a no contest plea, which means that you would do that by agreeing to take the consequence, but you would not have to make a statement because there's ongoing litigation. Is that what you understand as well?
Correct, Your Honor.
All right. Right now, you have certain rights, and I want to make sure that you understand those rights before you enter a plea. If you enter a plea today, you'd be giving up the following rights: the right to have a trial by a judge or by a jury, the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and to get an order from the court called a subpoena to require those witnesses to appear and testify. You'd also be giving up your right to testify or your right to remain silent. And if you chose to remain silent at trial, that silence could not be used against you. Also at trial, you'd be giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden remain with the prosecutor at all times. Finally, you'd be giving up your right to appeal automatically from any trial decision. And by entering a plea, you'd be limited to asking the court for permission to appeal. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Knowing all of those rights, is it still your intent to enter a no contest plea to the count 4 attempted resisting and obstructing?
Yes, Your Honor.
All right. I'm going to ask you to raise your right hand so I can swear you in just briefly. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir. Yes, Your Honor.
All right. Has anybody promised you anything or threatened you in any way to get you to enter this no contest plea?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right. Mr. Blumberg, I'm looking for the affidavit of probable cause. Do I have your permission to read that, to use it as for the factual basis?
Yes, Judge, or alternatively, there is a page entitled 0011 that has the written statements by Trooper Wenner that would also provide the court a factual basis. Either of those would be sufficient.
All right. I do not have the police report in the court file. At least I don't believe I do. So let me review the affidavit of probable cause, and I'll let you know if I have any other issues.
Okay.
I don't know how long he's going to review this for because I have not edited this. This was a gift from Lone Wolf Usul. So we're just going to have to wait this one out. The 10 days just started. on Thursday, I think it was. Or no, today. Today. That hearing was today. But this one was from the 3rd, which was not Thursday.
All right, I do believe the affidavit of probable cause satisfies the elements of attempted resisting and obstructing, in that it appears that the Michigan State Police, Trooper Kennedy, went to the scene where a person by the name of Rebecca DeGrez was living. Previously, Mr. Dash had lived at the same address, and there was currently a personal protection order pending that forbade him for being at that residence. Trooper arrived, followed him into footprints in the snow leading back through the yard, confronted Mr. Dash, and tried to arrest him, and he pulled away from the officers, tensed up, and resisted the arrest. So from that, and that all occurred on March 15th, 2025 within Otsego County. So I believe I do have a proper factual basis, and I do believe that Mr. Dash entered that plea knowingly, intelligently, and voluntarily. Are counsel aware of any other promises, threats, or inducements that were not placed on the record?
No, Your Honor.
I am not aware of any.
And do you believe that I've complied with the court rule as to plea taking?
Yes, Your Honor.
As do I, yes.
All right, I will accept the plea. Let me make sure I catch up with my paperwork here. Ms. Bruker, given the type of offense, do you believe that we need to have a victim impact statement or an opportunity for the officers to make a statement in court at sentencing?
No, Judge.
All right, Mr. Blumberg, are you asking to proceed directly to sentencing?
Sure, Judge, we could do that. I think it's important that the court ultimately understand the facts behind this whole incident. But yes, we can proceed to sentencing if that's what you think we should do.
I'm happy to give you additional time if you'd like additional time.
Here's the facts, Judge. His ex is crazy. A total nutter butter. She set him up. There's the facts.
Entirely up to you.
James, do you want to proceed to sentencing right now, or do you
Yeah.
want?
Yes,
Okay.
sir.
No, then let's
All
do.
right, that's what we'll do. All right, Mr. Dash, what I'm going to do is I'm going to let each of the attorneys give me their thoughts as to what an appropriate sentence would be. And then I'm going to give you that same opportunity right before I decide what to do with the case. So Ms. Bruker, your thoughts on sentencing?
Just to give the court a summation from the prosecutor's perspective of the facts, officers were dispatched in response to a violation of a personal protection order. On that date, Ms. DeGrez had a valid personal protection order that was still in place. Mr. Dash came to that residence, attempted to enter the residence. When police arrived, he hid himself behind a tree. He would not come out from behind the tree. They had to use some force to place him into handcuffs and to place him in the patrol vehicle. So here we are on that case. I mean, as to those facts. So what I would ask the court to do is to place him on probation. Even though Mr. DeGrez is not a victim on this particular charge, I've had conversations with her, and she's indicated to me concerns about substance use and other factors. So I'd ask that the court, instead of other types of programming that probation could order, I'd ask that the court order that he participate in a substance abuse evaluation and follow the recommendations. I believe there may be a no contact order with her as part of our bond in this case. And if the court is able to, I'd ask that the court continue that no contact order upon her request throughout the duration of probation. And aside from that, I just ask for other standard terms and conditions.
All right, thank you. Mr. Blumberg, your allocution.
Thank you, Judge. There is a long history regarding this case and my client and the mother of his child. Ms. DeGrez is in fact the mother of his child, She was residing in a home owned by my client. She, by virtue of an agreement reached in the custody matter, she was to have vacated that property. She was there well beyond the period that she was allowed. In spite of that, she contacted my client because there was some issues with the power and electricity in the house. The PPO that he was alleged to have violated was to expire the next day. So in spite of the fact that it was in place and at the direction of Mr. Grez, he came over he's an electrician by trade. He was going to provide services so that Mr. Grez and his son would have power in the house. He knocked on the door, and for whatever reasons, she didn't let him in. She called the police instead. Not perhaps understanding the gravamen of the situation, did attempt to hide, and he was arrested. The dismissal of most of the counts in this case come about because there's no legal basis for them. He was the owner of the house. He had every right to enter the house. He couldn't do damage to a home that he owned, so that count was dismissed as well. Mr. Dash has no prior criminal record. This really was about his concerns about his son. And while perhaps he should have waited to the following day while the PPO had expired, he went there based in good faith, trying to provide some services for his child and the mother of his child. I believe that a period of probation, if the court feels it's appropriate, would not need to require any substance abuse counseling. This had nothing to do with alcohol. It had nothing to do with controlled substances. Mr. Grez and Mr. Dash continue to be involved in custody matters, and I believe they're actually even before you at this point. So her concerns at this point is making sure that he doesn't get to see his child. So, Judge, currently Mr. Dash is residing downstate. If the court were to place him on probation, we would respectfully ask the court to allow the probation to be transferred down to Macomb County, where he is currently residing. I think a short period of probation, if any, is appropriate and merely fines and costs. Thank you.
Judge, I don't want to get in a back and forth, Mr. Blumberg, but there are two small factual things about the dates that I could correct if the court would like me to.
Go ahead.
Just the personal protection order was valid through March 19th, and this incident occurred on March 15th, and it was around 3 in the morning when Mr. Dash came to the residence. That's all I wanted to add for context.
All right, thank you. Mr. Dash, you have the right to also address me prior to the imposition of sentence. Is there anything else that you would like me to know?
Yes, Your Honor. I arrived at the home at 3 a.m. because I was been busy moving locations, and it was easier for me to do that at nighttime, in the night hours, than during the day. When you're moving a shop, there's a lot of materials, there's a lot of stuff, and it's just easier to do at night. Rebecca DeGrez had approached me to come over and, like Mr. Blumberg said, do some work. And when I got to the address, I was confronted by the police. I made a flight response that I regret. And I do agree with what Mr. Elliot Blumberg said. And I do apologize for my actions of going over there 4 days earlier. But I had zero contact with her, and I was only harassed by her during the whole duration of her PPO. And it's been used to elicit my son against me. And that's kind of all I have to say.
All right. Anything else that you want me to be aware of?
I don't believe so, Your Honor. I believe that if I was to, I'm more than happy to pay fees and fines. I don't feel like probation is necessary. I'm 36 years old. I've never been in trouble once. I feel like most of this case is more just a family matter than anything, and I was wronged by her. I feel like I didn't have really criminal intents, and I still don't. And I feel like if there was to be probation, that it should be non-reporting. But at this time in my life, this junction in my life, I'm still a business owner. I still have a ton of responsibility. I have to be all over the state. It would make probation incredibly hard for myself. And I don't feel as if that should be even a consequence to these actions. I feel like not seeing my son for over 2 years has hurt me more than anything that a court system could inflict on me.
All right, thank you, Mr. Dash. Your attorney asked if the probation could be transferred down to Macomb County. I don't think that's going to be necessary. Typically, most probation interviews or contacts is via Zoom and video. So I think wherever you're living at, you'll be able to report with and discuss the matters with your probation officer here. I'll leave that to her discretion. However, typically I wouldn't be granting that request up front. The other general comment that I'm going to make before I become specific about what your sentence is that it appears to me that you've got some decision-making problems. I get it that you could have a fight or flight response when first confronted with the police, which would cause you to hide behind a tree. But once they find you and tell you that they're going to put you under arrest, fighting with the police just exacerbates the problem. And it's one of the largest reasons I'm going to put you on probation. Because if you're making a decision to fight with the police, then we certainly need to monitor your behavior because you're not making good decisions at that time. The other thing that bothers me is that you're at your ex-wife's or your mother of your child at 3 o'clock in the morning. I don't care who you are, or whose house it is. You don't come to anybody's house at 3 o'clock in the morning without asking for permission first, whether you own the house or not. If somebody else is living there, whether you think it's right for them to live there or not, you don't come to anybody's house at 3 o'clock in the morning.
Your Honor,
this is not your time to talk. This is my time. Okay. 3 o'clock in the morning is not normal business hours. It's not even closely related to normal business hours. You just don't show up. That's just common sense. And if you're not able to make that level of decision making, then the court's going to need to monitor your decision making to
Your
make
Honor,
sure
I
that
need
it
to say
is
something.
appropriate.
James, stop.
I know you want to explain your behavior, but it's too late for that.
No, I was invited over for sexual intercourse.
You're not making it any better, Mr. Dash.
Well,
Do what
that's
your
why I was there
attorney
at 3 a.m.
advises-
if we're talking
do what
about
your
why I was
attorney
there at 3
advises you to
a.m.
do and keep your mouth shut, sir.
Okay.
All right. I'm going to put you on probation for 180 days. There'll be a probation oversight fee of $180 for that. There's a crime victim fee of $75, a justice assessment of $50.
Can we please get a mental health evaluation if he was willing to do that again? He needs a psych eval stat.
Court costs of $300, a fine of $150, and a local charge of $15. Let me add that up for you. It's a total of $770. You can pay that off over the course of your probation. You may perform community service work in lieu of some of those fines and costs at the discretion of the probation department. I am not going to impose substance abuse or drug screens on you because there doesn't appear to be any credible information at this point that you did that. But again, your decision-making bothers me. I am going to continue the no contact. You may not associate with Rebecca DeGrez. Unless in compliance with a custody order. So if there's an outstanding custody or parenting time order, or if there's one in the future that's being done, you may have contact with her only for the limited purposes of custody and parenting time as that other order requires. There will be no assaultive, abusive, intimidating, or threatening behavior because of the nature of the allegations of again, your behavior with the police officers.
Does the order for him being allowed to have contact with her for custody and parenting time, does that include his trying to, make new parenting time with her for the next kid they're going to have after he knocks her up from his 3 a.m. booty call?
Are you working downstate, sir?
Yeah, I'm working in Romulus.
You work Monday through Friday schedule,
Yes, sir. Yes, Your Honor.
40 hours a week?
Plus.
Ms. Hill, are you with us from the probation department?
She's been a week.
She's gone already?
Yep.
All right. I'm going to require you to enroll or have an assessment done to see whether you should enroll in an anger management class.
I agree he needs that anger management class.
I'll leave it to Mr. Blumberg to assist you in finding how to do that. The reason I was going to contact Ms. Hill was she's the probation officer here. She may have some ability to help Mr. Blumberg find one of those or find out how to get assessed for that. But I'll leave that to your counsel. If you are assessed to qualify for that anger management class, you must enroll if recommended and follow all recommendations. That is what type of class and how long it's going to last for and what you have to do because of that class. All right, that will be the order of the court. Any questions that you have, Mr. Dash?
No, Your Honor.
Mr. Blumberg, anything?
No, Judge, thank you.
Ms. Brooker?
No, Your Honor.
All right, that's all for today then. Thank you very much.
Well, you would understand that one, wouldn't you, Richard Cranium? Oh my gosh, that was so much fun. And thank you to Lone Wolf of Soul. Thank you for giving us that second gem. Oh boy. Oh, what an idiot. Oh. Oh, we've all got them. Some people just can't grow up. That's the long and short of it. All right, guys. It is 9 o'clock. I don't know if I'm going to have time enough to get anything edited to come back on. So if I do come back on, we may just watch body cam videos. Who knows? I may find a gem in there. I'll still try. I will try. I know. It was so great. I'm still kind of biased and fond of the first case more just because that was mine. We will see. Maybe we'll do a hybrid. Maybe I'll find something amazing and stream the videos and throw in a body cam. Yes. I have to monitor my mouth and come up with other ways of saying things. All right, guys. Thank you so much for coming and hanging out with me. Be safe, be well, stay sweet, and much love.